We're just going to wait a few minutes and allow people to join, and we will start. Okay, I think we can start. And as people join, I ask that they at least say hello so that we can see in the comment section, so that we can see who's joining and they are able to participate. We also ask that people do send comments as the discussion is going on. If there are questions, please send them in the comment section, but let us engage, because this is one of the most important topics, I believe, in the period that we are in. And we have seen worrying stats coming out. So we want to understand. Let me start officially the program. My name is Fina Kodisang, the CEO of the Soul City Institute. Thank you. We welcome you. We see you, Tobile and Mpo. Thank you for joining. And everybody else who has joined, we welcome you. So in the 16 days of activism, Soul City has termed the period, or has embarked on a campaign that we are calling Kalimelang. And Kalimelang is a Sotho or a Tswana word that means hold to account, call to order. And we want to hold to account, and we want to call to order the issues that we feel have been neglected in our country. We want to call to order those that are supposed to take action and are not taking action. We want to call ourselves to order for being bystanders, because some of us are bystanders. When we see things happening, we don't take action. We just watch, we just make comments on our Facebook statuses, we just comment on our social medias, but that's as far as it goes. We don't really take action. And World AIDS Day was about moving us from awareness to accountability. So we are in the same breath holding everyone, including ourselves, as advocates, accountable for the issues that continue to be perpetuated in our country. Everybody has a role to play, and you will see with the panelists that we have that it's a multi-stakeholder panelist, because we understand that you can't deal with the issue from one sector. You need to incorporate everybody. Everybody must be part of the solution. So let me start, and how I will do it is I will introduce my guests one at a time as they speak, but we have a high panelist, let me call it that, specialists, experts in their field, people who work every day to make sure that we make our country a better place for the children of South Africa, for the young girls of South Africa, for the women of South Africa, for the people of South Africa, because it is about all of us. So thank you very much to the panelists. Looking forward to a robust discussion. And again, I ask that those who are joining us, please do send your comments so that we are able to engage with the questions that you have. Karin, let me start with you. You are head of corporations at the UNFPA in Canada. You are going to give us an opening address to this webinar and to this discussion that we are about to have. Over to you as you introduce yourself and tell us more about who you are and the work that you do, as well as give us an opening address. Over to you, Karin.
Thank you very much for the warm welcome, and thank you for inviting me and allowing me to do these opening remarks. I really appreciate the opportunity to be able to participate and hear from this robust discussion. I think, as you said, it's a very important discussion. And I have also myself just recently arrived to Pretoria as the new head of cooperation. My predecessor was here for several years and has been working with you, with UNFPA and UNICEF on this program, and we focus our international assistance on women empowerment and gender equality, as well as inclusive governance. So it's a great opportunity for us to be able to support these types of projects and be able to present. So with that, if you allow me, I'll start my remarks officially. So thank you. And again, let me start by acknowledging our hosts, UNFPA and Soul City Institute. I would also like to acknowledge UNICEF, who are the co-implementers with UNICEF on this joint program. Thank you, everybody, for your participation. And ladies and gentlemen, all protocols are observed here. Thank you for allowing me this opportunity to say opening remarks at this webinar on statutory rape. The concept paper for this webinar presented shocking statistics. In September 2021, the Khotan Department of Health reported 934 cases of adolescent girls who gave birth. Nationally, that number was of 34,587 adolescent girls who gave birth. And what is most disturbing and alarming is that out of that national statistics, 688 were children aged between 9 and 10. It is clear that we're not only dealing with an issue of sexual and reproductive health, but also sexual and gender-based violence. Something needs to be done, and it needs to be done urgently. Canada supports the goal of ensuring that every pregnancy is wanted, every birth is safe, and every girl and woman is treated with the dignity and respect she deserves. As part of Canada's feminist approach, Global Affairs Canada is committed to supporting access to the full range of services for information on sexual and reproductive health. Access to sexual and reproductive health and rights are critical to advancing gender equality and the empowerment of women and girls. Lack of attention to sexual and reproductive health and rights contributes directly to maternal mortality, poor health, and the disenfranchisement of women and girls. We will only achieve the SDGs if we make progress in addressing gender inequalities and ensuring that women and girls are able to make decisions about their bodies and their futures. Canada's Feminist International Assistance Policy places gender equality at the empowerment of women and girls in all their diversity at the center of international assistance, and commits to addressing the unacceptable rates of sexual and gender-based violence experienced by women and girls. This includes supporting comprehensive approaches that help and end SGBV and address the social norms and gender inequalities that are the root causes of SGBV and harmful practices. And this is a significant element of Canada's support to the project run by UNFPA and UNICEF jointly in South Africa. Too often, violence against women and girls is normalized and goes unpunished. If it weren't so, we would not have alarming statistics on statutory rape as we are dealing with today. SGBV has devastating impacts on the individuals, families, and communities. The effect of such violence can be long-lasting and profoundly affect many aspects of a person's life. Canada condemns, in the strongest terms, all forms of SGBV wherever it occurs. Worldwide, the COVID pandemic has triggered an alarming increase in SGBV. Using an intersectional feminist approach, our international assistance response to the pandemic has prioritized actions that have addressed gendered impacts on COVID-19. And we have also targeted the most marginalized, particularly through supporting local organizations working on the front line. Efforts to respond to the increase in SGBV as a result of the pandemic and ensuring access to essential health services, including SRHR, are central components of this response. As we are within the 16 days of activism, this is a significant campaign. It is an opportunity to come together to call out, speak out, and renew our commitment to end gender-based violence. Furthermore, the 16 days is also an opportunity to come together to address injustices and take immediate action to create safe homes, communities, and workplaces for everyone. Now more than ever, collective action against gender-based violence is needed as we navigate the evolving COVID-19 crisis. Moreover, we are all aware that our voices need to be loud 365 days of the year. For that, let us continue working to build strong partnerships, funders, media, government, multilaterals, CSOs, including churches, traditional systems, men and boys. We all need to work together to advance gender equality and end violence against women and girls. It is in all of our collective best interest to do so. I thank you again for this opportunity to make these remarks, and I look forward to the discussion. Thank you.
Thank you, Karin. And I'm happy that you mention, feminism as an ideology that we can look to, and in doing the work that we are doing, in approaching the issues that we are faced with, because Soul City Institute identifies itself as an intersectional feminist organization. And at the center of our core work is a young woman and a girl, because we understand that they are the ones who bear the brunt of the many issues and the many social ills and the many pandemics that we face in South Africa. They are the most vulnerable to HIV infection. They are the most vulnerable to gender-based violence and femicide. And they are the face of poverty. Black African young women live in poverty in South Africa. So when we look at issues, we don't look at issues from one lens. We look at issues from an intersectional lens, on the basis of race, on the basis of gender, on the basis of geographic location, because being in rural South Africa in current day means young women are marginalized. They are excluded. They are also excluded on the basis of their sexual orientation, because we still live in a society that is very homophobic. We still live in a society that treats children and women as second-class citizens. So intersectional feminist approaches are needed when we look at what are the solutions and how do we deal with this monster called patriarchy. That is the reason why we find the many issues. And I'm sure as we discuss today, we will see how patriarchy is the reason why we have so many ills, so many harmful norms, how rape culture has been normalized to the point where children can be violated and society does not feel a need to take action, because it has become a norm. It has become something that we are expecting. It has become something that we live with, something that we accept. But we are together today saying we are not going to accept that. We are not going to stand by and just watch and just accept numbers as they are reported. So I want us to get into today's discussion. And thank you, Karin, for opening. Your opening remarks really reflect how as Soul City we want to deal with this issue. So we are aligned, and thank you for the partnership that we have with UNICEF and with the UNFPA. Let me bring you in here, Dr. Llewellyn. You are the only male. Interesting. So each time we get asked, what about the men? But we need to understand, and I want you, because you come from the Child Law Center, I want you to help us understand the law. I want us to put a child in the context of the law. What does the law say? What do we define as a child? And what does the law say about the protection of the person we consider a child, before we get into, statutory rape and everything?
Yes. Thank you very much for the opportunity. And thank you for the kind words, Corinne, from your side as well. It is acknowledged. And I think this is a very worthwhile opportunity to debate this issue that needs to be addressed on all levels correctly. From my side, also, all protocol observed. That being said, time is of the essence, so let's just get into the nick of things. First of all, I cannot underestimate the importance of the topic. That being said, if one talks about sexual offences and related matters, then it's a very, very broad topic in actual fact. And for what it's worth, I'm sure I can keep you busy for the rest of the day, if needs be, exclusively on our Sexual Offences Act and anything related to that. But since our topic is very specific concerning children, and specifically statutory rape and more or less issues relating to age of consent, that will probably be where I will draw the line and limit the discussion exclusively to those issues. First of all, a couple of necessary definitions is important to understand the law in South Africa as far as this is concerned. For what it's worth, let's start, and I will only highlight 4 or 5, the most important ones that I have identified. First of all, what do we understand by the word child? Now, in South Africa, as in many other countries in the world, I suppose, a child is specifically defined as any person under the age of 18 years of age. You will remember a decade or so ago, the age of majority was 21 years of age and older, but that has been reduced, and currently a child is considered as any person under the age of 18 years of age. Then we have to look at the definition of rape. Maybe I should just add this. Currently, anything relating to rape, and that includes statutory rape, etc., have been codified. In other words, have been defined in statute. In other words, unlike 10, 20 years ago, where we also had the common law still applicable, these days, anything relating to rape and sexual offences are more or less codified in our Sexual Offences and Relators Amendment Act, Act 32 of 2007. So on the one hand, it makes it easier because we can always go back to the legislation, apply our mind, and merely look at the act and say, but listen, this falls in the parameters of the act, or it does not. We do not have to go back to the common law, in other words, our Roman Dutch heritage, to find out when a specific crime has been committed or not. Now, rape in terms of Section 3 of this act that I've referred you to provides that any person who unlawfully and intentionally commits an act of sexual penetration with a complainant, and let's call the complainant B, such a person, without that consent, will be guilty of an offence, and that will be rape. In other words, from that word definition in Section 3, 2 very important aspects come to mind. Consent, the word consent, and second of all, a term which is defined as sexual penetration. Now, that being said, there's another very important, let's call it then, crime which we identified and typically will find where children are involved in. And that is defined in Section 5 of Act 32 of 2007, which I referred you to, which we call in legal terms so-called sexual assault. Sexual assault is defined in more or less 2 or 3 categories. First of all, if a person, let's call that person A, unlawfully and intentionally sexually violates a complainant, the complainant, let's call that person B, without the consent of B, that person is guilty of the offence of sexual assault. A second category of sexual offence will be the situation where person A unlawfully and intentionally inspires the belief in a complainant, B, that B will be sexually violated, then you are also guilty of the offense. So in this instance, it's not only the act itself, but also where there's a belief that inspires fear to that extent. That will also then comply with the requirements of the crime. I've referred you to the word sexual penetration. Now, this is an important definition, and that's why I need to mention it as well. Because sexual penetration is specifically also defined in Section 1 of this Act that I've referred you to. Now, it defines, obviously, the ordinary interpretation of sexual penetration as we all know it, where there's penetration by one person to another without that person's consent. But then, interesting enough, it also includes, and this broadens the spectrum and the scope of the applicability of the Act to the following. It includes any act that causes penetration to any extent whatsoever by, first of all, the genital organs of one person into or beyond the genital organs, anus, or mouth of another person, or B, any other part of the body of one person, or any object, including any part of the body of an animal, into or beyond the genital organs or anus of another person, or C, the genital organs of an animal into or beyond the mouth of another person. So what I'm saying is sexual penetration per se should not be restricted and limited in its scope of application, because from the word definition of our law, the statute regulating this offense, it is clear that basically any act of inserting any body part into the orifices of any other person, male or female, will already be classified as a transgression in that regard. So in terms of the perspective from a common law viewpoint, it is clear that our legislator over the last, and this act came into operation in 2007, over the last 2 decades have broadened the scope of rape, including statutory rape and sexual assault and related matters, enormously. In comparison to 30, 40 years ago, there's no less than almost 50 or 60 new transgressions, statutory crimes that will be committed if you contravene some of these acts mentioned in the Act. Okay, so that brings me to the definition of statutory rape, because this is what we are talking about today specifically. Statutory rape means, in the South African context, consensual sexual penetration with someone who is a child. And that child's definition is then specifically also then defined by reference to Section 51 of Act 32 of 2007. So we need to understand that if we talk about statutory rape, we are talking about consensual sexual penetration. Otherwise, it will be clearly out and out rape. And we do not then necessarily have to define it as so-called statutory rape. Okay, so that in essence, so what is meant by consent? Because it's important that if we are talking about consensual sexual penetration, we need to understand what is to be understood in South Africa under the term consent for purposes of law. Consent does not mean agreement or consensus. Agreement requires a meeting of the minds between 2 or more people and is basically, therefore, a bilateral or a multilateral act. Consent, on the other hand, is a unilateral act. For this reason, consent can therefore be withdrawn unilaterally by any person at any time. Consent need not only be expressed in words, whether written or spoken, but can also therefore be given tacitly by conduct. However, and I must state this unequivocally, mere silence or submission does not amount to consent. Even in cases where consent is a valid defense in law against the so-called unlawfulness of the act by the accused, then obviously the crime can still take place and a person can still be convicted because the consent needs to meet the requirements for a valid consent in terms of our law. And this means, first of all, the person giving it must have the necessary, what we call legal capacity to consent. And this is where children specifically comes into play as well. Second of all, the consent must be a genuine consent. And in the third instance, it must be operative at the time of the act in question. Now, regarding children, it is obviously this first mentioned requirement of valid consent that is of importance. To be valid, the consent must have been given by a person who at the relevant time was mentally capable of forming and exercising his or her will. Now, the general accepted test is whether the person concerned was capable of understanding and appreciating the nature of the act or the transaction applicable to which he or she apparently gave his or her consent. The following persons in the South African law lack such capacity to give valid consent in law. First of all, mentally ill persons. Secondly, persons who are intoxicated, either being drunk or as a result of drugs, to the extent that I've mentioned. In the third instance, obviously people that are asleep or unconscious, to the extent that I've mentioned. And most importantly, in the fourth instance, persons who are too young. Once again, this is where children comes into play. The general rule at common law was that any person under the age of 7 always were deemed incapable of consenting to any act whatsoever. If you were older than 7 years of age, then the validity of the child's consent would have depended on whether he or she was able to understand and appreciate the nature of the act to which the alleged consent was given. And then factors such as intelligence, education, background, and so on were also considered. Thus, in short, a person need not be a legal major, in other words, over the age of 18, to give valid consent. Now, there are certain, obviously, let's call it exceptions to the rule. And this is in terms of the statute that I've mentioned. First exception that comes into play, and which is important for our discussion today, is that the common law exception relates to the age of consent in respect of sexual acts was modified and altered. Now, in terms of the common law, as I've tried to explain in very, very short summary, was that only sexual acts, in case of girls only, were basically considered to be a transgression of the law. There was an irrebuttable presumption that a girl under the age of 12 years of age could not validly consent to sexual intercourse. And therefore, that always amounted to rape, even if the girl understood the nature of the sexual act and gave her consent. We've got ample case law in that regard. cases like Rex versus Z and others. But this presumption was, however, eclipsed by the Sexual Related Amendment Act 32 of 2007 that I've mentioned earlier on, which replaced the common law definition of not only rape, but other related issues as well, and currently provides that any child, whether male or female, under the age of 12, is incapable of appreciating the nature of an act of sexual penetration or violation, and thus, in short terms, incapable of giving valid consent. Specifically, Section 1, sub 3 of that Act defines exactly what I've tried to state here. Then another important aspect is Section 14 and 15 of the what we call the old Sexual Offences Act 23 of 1957. In that act, the act went further than our common law and made it a statutory offence for a male to have sex or attempted to have sex with a girl under the age of 16 years. Or for that matter, for a female to have sex or attempted to have sex with a boy under the age of 16 years of age. Now, this offence was commonly referred to in popular parlance as so-called statutory rape in, let's call it, the old system of our law. But in fact, it was not rape at all, but rather a separate and distinct statutory offence. And therefore, your ordinary penalties for transgressions associated with rape were not applicable. Now, Section 15 and 16 of the, let's call it then the new Act, Act 32 of 2007, if you like, replaced these previous provisions by making it an offence for a person of either sex to perform or act any act of sexual penetration or violation with any child under the age of 16. We must also bear in mind, and I think Karine mentioned it in her introductory speech. She said there are certain medical procedures or choices that we need to understand as well when it comes to children. Section 129 of our Children's Act deals with any aspect regarding the various medical procedures as well as choices, including choices regarding termination of pregnancies for women specifically, regardless of their age. And in terms of the choice of termination of pregnancy act, specifically Section 5, sub 2 of that act, a woman, regardless of her age, can choose to terminate her pregnancy at any stage. There are obviously certain legal limitations to that as well, but that's the general rule. Some acts are so personal in nature, for example, sexual acts, that no one can validly consent to such an act on behalf of another person. The so-called consent by proxy situation, if you'd like. And I put this in quotation marks. For example, therefore, a parent, a guardian, a caregiver, even the Minister of Health, a children's court, or the High Court, which is considered the upper guardian of all minors, cannot validly give substituted consent to undergo or for an underage child to have sex. In short, to summarize my, let's call it an introductory speech, if you'd like, if we talk about statutory rape, and to put it in layman's terms, we need to understand a very, very short, brief history on it, and it will not take more than a minute. Sexual abuse and indecency against a person who is legally classified as a youth have been punished throughout the common law and statutory law of this country for decades. But in my mind, and this is my personal opinion, I'm very happy to say that we've made tremendous progress since at least the 2000s up to now, where we have expanded the common law and also the previous Sexual Matters Act. Section 14.1 small b of the Act that I've referred to, Act 23 of 1957, prohibited males from committing or attempting to commit an immoral or indecent act with a boy under the age of 19 years of age. In other words, consent by a male under 19 years of age could not exclude liability of an accused. In short, it means homosexual acts between consenting women, for that matter, were not criminalized in this country until 1988 in terms of what was known as the Immorality Amendment Act 2 of 1988. That resulted then in another inclusion in our sexual related act, namely section 14 sub 3 sub b, which stated that it became a criminal offense for a female to commit or to attempt to commit an immoral or indecent act with a girl under the age of 19 years of age, 19. But note in what I've said here, nowhere in either section 14.1b or section 14.3b were there any suggestion that the age of the offender was relevant for purposes of transgression of the statute. Therefore, offenders could also be younger than 19 years of age and be prosecuted. If both participants were obviously over the age of 19 years of age, then there was no crime at all, especially once the crime of sodomy was repealed in the matter known as the National Coalition for Gay and Lesbian Equality case. That one was against the Minister of Justice and Constitutional Development in the Constitutional Court of this country. Ever since then, it's okay. Section 14 of that act that I've referred you to also criminalized sex with children under the age of 16 years of age, but identifies certain defenses which could have been raised by an accused to exclude liability. Conduct, for example, where the child was a prostitute and the accused was a first-time offender younger than 21 years of age. Or for that matter...
Llewellyn?
Yes, ma'am.
Because you are, it's getting deeper, and the law is something that we are not familiar with. We need to take it one step at a time. Otherwise, then people get lost with, with everything that you've said. They don't remember the gist of what we want to get to.
Can I conclude with the following?
Yeah, we want people to understand why when a 10-year-old is pregnant, we say it's statutory rape. And I think you had highlighted that.
Let me cut it short.
Yeah.
If either a male or a female commits an act of sexual penetration as I've defined, with either a male, a boy, or a female, a girl under the age of 12, it's rape. Period.
Mm-hmm. Mm-hmm.
If either a male or a female commits an act of sexual penetration as I've defined, that broad definition, or violation, which will amount to sexual assault, with a person under the age of 16 years of age, whether a boy or a girl, then it will amount to what is known as statutory rape. But in terms of section 15.1, 15 sub 1 of the act that I've mentioned, and this is the important aspect, and that was also the conclusion reached by the Constitutional Court in the so-called teddy bear clinic case. There is an exception, and let me just refer to this issue, and then that will conclude my argument. A person, let's call the person A, who commits an act of sexual penetration with a child, B, who is 12 years of age or older, but under the age of 16 years, despite the consent of that person B, in other words, the child, will commit an act and be guilty of the offense committed, in other words, whether there was consent or not, unless A, at the time of the alleged offense, himself or herself was also 12 years of age or older and under the age of 16, alternatively, either 16 or 17 years of age, but the age difference between the two, A and B, was no more than 2 years. So that is the bottom line, if you'd like. I hope that makes it clear and very practical.
Yes, we want to simplify it because we really want people to get an understanding of what we mean when we say rape and what we mean when we say statutory rape. And so, Joanne, welcome, Joanne van Niekerk. We are happy that you were finally able to join us. You are
Thank
a
you.
child protection specialist, and given all the definitions of the differences between what constitutes statutory rape and what Lueno was explaining to us, what is it that in your line of work you see happening? Is there an understanding of what the law says around the age of consent? Is there an understanding in generally of what rape, statutory rape is? I mean, even among young people, because he spoke about 12-year-olds, 7-year-olds, 10-year-olds, and the numbers that we are referring to that we've seen all over media tells us that as young as 9, girls have been impregnated and have given birth. So what is your sense in terms of these numbers? Do you feel that these are a true representation, or they are just what is reported? There might be in a worse situation that we are not aware of. Tell us what you've seen in your line of work in line with statutory
Yeah.
rape and the violation of children generally.
Indeed, when we look at pregnancy figures, we're only looking at children who have fallen pregnant and have delivered babies. And this is very concerning because it does not include children who do not fall pregnant. It does not include children who've gone for terminations of pregnancy. I think we should be very concerned. I don't think that children truly understand the issues around age of consent. And I think this is something that needs to be included in our life skills education, which I think, unfortunately, the Department of Basic Education has called sexuality education. And really, when you look at the manuals that are available for learners, it focuses on life skills more than it focuses on sexuality. There's been a lot of hype over this, and I think basically it's the title that people are responding to. But having said that, I don't think professionals understand it either. And also, professionals do not understand their obligation to report. And when they do sometimes understand their obligation to report, they don't report because they don't want to appear in court, or they do not want the kind of issue of responsibility. Now, having said that, I work in communities sometimes where intimidation is rife. So an educator or perhaps even a social worker might say, yes, we've known about this, but we've been threatened, etc. So the Sexual Offences Act has a compulsory reporting obligation for every citizen in this country. That includes all of us, you, myself, people on the street, etc. If they know about a sexual offence, it's got to be reported to the police. I think this again is something that we need to have another look at because of intimidation and because sometimes the police make very arbitrary decisions, even though they're not supposed to, about whether or not they will open a docket, put it in the occurrence book at the station, allocate it to an investigating officer, and take it forward. This is very problematic. I've dealt over this last year with a large number of children. I do consultation for a trauma center with the staff. So when I say I've dealt, it's through the staff with a large number of situations this last year where it has been reported to the police, no docket has been opened, and nothing further has been done. Or else it goes to a Tutuzela care center. And I must give acknowledgement here. The Tutuzela care centers have indeed made the first reporting situation a lot more child and victim friendly. But after that first report, no support for the child. So this morning, for example, in my consultation with staff, we discussed a case where the child had reported, gone to a Tutuzela center, had a good experience, but there was no networking amongst the professionals. The child was removed from home, and even once the grandfather had been charged, he was allowed to stay in the home because it was an extended family unit, but the child was removed. The child longed to go home, longed to go back to her school. The offender could have been removed from the home. Even if he owned the home, he could be removed from the home. But because of the lack of knowledge of legislation, because the Sexual Offences Act has to be taken in conjunction with the Children's Act when we're looking at children, and the lack of case conferencing amongst the professionals, this child was removed. Eventually, the child said, I don't want to go on with this case. I refuse to testify. So charges were withdrawn. She's gone back home. Grandfather's gone back home. Have we protected this 12-year-old? Not at all. So it's not just a knowledge of the law that is important. It's role players must be faithful in implementing the law. And in order to do this properly, we've got to consult with the families, with the children, with other professionals, and take it forward. So, short answer to your question, no, children don't know the law. Neither do many professionals. Many professionals, when they know the law, don't necessarily implement it. And we need to build a culture of responsibility and accountability on this issue.
Thank you. I don't see. Oh, Daphne's back. I thought I had lost you there, Daphne. And you are raising something that I think is important that we reflect on. The fact that yes, we want children to know what the law says, so that they are able to then report. Because when you don't know that you have been violated, you might not end up taking action. So we want children to know, and that is why programs such as the comprehensive sexuality education that is implemented by the Department of Basic Education is important. And Managa Pillay is saying there that the title, you were raising issues around the title and the confusion that comes with the title. Managa is saying there, the new SLPs, please help us with clarifying. Sometimes we use acronyms and we forget that not everyone knows what these acronyms are. The comprehensive sexuality education and the new workbooks and guides have tried to address the issues of consent. I think Llewellyn tried to unpack consent, and he also indicated that it can be withdrawn anytime. So we might start with me saying yes when we start, and during the act I say no, I don't want to continue anymore. At the time I say no, the expectation is that you should stop because I'm withdrawing my consent. And that's something that is being raised here, where Managa again says consent is fluid, and that is why it becomes complex, and we've seen the complexity with the Koko case, where, you know, someone agreed to kissing, and it was mutual between the two of them that what we will do is foreplay and kissing, nothing more. But it got complicated because the person then went further than what was agreed to, and now it ended up with, you know, the person being sentenced and ultimately that being changed, which is still a problem. So we need to get to a point where everyone understands consent and the fact that it can at any point be withdrawn. But I like that you are saying there's an obligation to report, and the Child Protection Act is important for us to understand who has the responsibility to report before we answer and pose questions. So I want to bring you here, Daphne, because you work for social development, and the Department of Social Development is involved. You know, we know that social workers and other social programs, you know, would reside within the Department of Social Development. So please unpack for us, you know, this protocol in terms of reporting, who has the responsibility, especially when it's children. You know, I know in our policies at Soul City, we say every person, including the workers of Soul City, if they know of a child being violated, they have a responsibility, they have a duty to report. Tell us what the Child Protection Act says, and also tell us what you do in relation to what we are talking about today. Over to you, Daphne. Daphne? Okay, it seems like there's a problem there. But let's maybe answer this question then while we wait for Daphne to check her Wi-Fi and her connectivity. Are you back, Daphne?
I am back. Thank you. Thank you for that. And I hope everyone can hear me. Okay, colleagues, it's quite important. The Sexual Offences Act is quite clear that everyone has to report when it comes to abuse of children, sexual abuse of children. But specifically, I want to go into the Children's Act. And Section 110 of the Children's Act makes it clear, because these are mandatory officials that needs to report. And the mandatory officials are any correctional official, your dentist, your homeopath, immigrational official, labor inspector, legal practitioner, medical practitioners, midwife, minister of religion, nurse, occupational therapist, physiotherapist, psychologist, religious leaders, social services professionals, social worker, teacher, traditional health practitioners, traditional leaders, or member of a staff, voluntary worker at a partial care center, dropping center, or child and youth care centers. Now, these are mandatory people. Okay.
Oh, okay. Daphne's
that the
network
law
is
is saying, in terms of the Children's Act, any child that is abused or deliberately neglected.
Okay. I hope you find, you know, better connectivity there, Daphne, because we are struggling to hear you. Let me then, you know, Llewellyn, in short, Mpho is asking a question about the different age groups, you know, and in terms of what you were explaining, she's saying, and there's another question here around the specifics. When we say under the age of 16, are we also saying 16-year-olds? So where does the age cut off? Is it 16 included or below 16? Let's include that in answering. But also Mpho was asking, and let me try to find that question that Mpho asked.
I have the question available.
Yes. She says if it's two minors who are over the age of 12 but are under the age of 16, when they engage in a sexual act, who is charged with statutory rape? So
Okay.
are minors under the age of 16
not
legally
sure.
allowed to engage in sex? I believe you said they could, but
I was audible at that.
Thank you.
Sorry, Daphne, we will come back to you. Let Llewellyn answer these two questions quickly, then
Okay.
we come back to you.
Mpho Lebaka, she had a question, and the question was basically the following. With two minors over the age of 12, but under the age of 16, engage in consensual sex, because otherwise it will be rape. So in other words, we are talking about statutory rape as she defined it here. Who will be charged with statutory rape? So we have a situation, we've got two people, whether two boys with two girls or with a boy with a girl, it doesn't matter, over the age of 12, but under the age of 16. In other words, 16 or younger. And they have consensual sex. Which one of the two will be charged with statutory rape, so-called? The fact of the matter is, until 2014, when the teddy bear case was reported in the Constitutional Court, the Director of Public Prosecutions had a choice. And usually, in many instances that led up to that specific case, decided to charge both these two children, so to speak, because children are people under the age of 18. But then Section 15.1 of the Act was amended and included in the Sexual Offences Act to make provision for this specific problem. And ever since 2014, these days, if there is consensual sex between these age categories, and on the assumption that they have consented, then the NDPP will be very hesitant to charge a person with so-called statutory rape. Even in the situation where one of these participants were 16 years or 17 years of age, but the age difference between the two of them is no more than 2 years, then there must be a direct instruction in writing by the National Prosecuting Authority in terms of Section 15, Subcategory 2 of the Act, before a prosecution will follow. So in short, we will not charge either one of the two young adolescents of rape.
Okay, thank you. If a 17-year-old, if a 16-year-old has sex with a 14-year-old, what happens in that instance?
Well, then we have a clear situation of so-called statutory rape.
Yes.
Then we will definitely see this matter proceeding to court. Obviously, there are certain issues that you need to understand as well. The age of the perpetrator, the accused, will always play a part when we get to issues regarding sentencing, for example, because a person of young age will be considered more lenient when sentencing is imposed in comparison to a person over the age of, say, 25, 30 years of age, etc., purely because of his young age. But there are prescribed minimum sentences applicable where you get charged and convicted of rape and statutory rape included, which includes nothing less in many instances than life imprisonment for a child, for the first offender as well.
Yeah. Okay, so it is clear to everyone listening, even if it's a 16-year-old who's had engagement, sexual engagement with a 14-year-old, they have violated, because that's considered statutory rape. And when they are reported, then the matter must be dealt with according to how you are defining it, Luen, right, as statutory rape. Okay, so I think we have cleared the confusion around what constitutes statutory rape. It does not necessarily only mean if it's a 20-year-old who's having sexual intercourse even if the consent is given, it doesn't mean that it's only when it's a 20-year-old or a 30-year-old. Even a 16-year-old who's having sexual intercourse with someone under that age, 14, 10, that is considered rape.
I see
Okay.
Daphne had Joan have a important issue she wants to raise. Maybe she can add on here.
Okay. Joan, kiss it.
Right,
Keep
very
it.
short. Okay. I just want to mention, someone wrote a question about parents if they refuse to report. Anybody who refuses to report is guilty of a crime and also can be charged and sentenced as a result of their failure to report. However, again, this is a very unused provision in the Act. And I have yet to see someone who has been charged with this and successfully prosecuted. On the other hand, I recognize I don't see a lot of, I can't speak for the entire justice system. So that is an important response to the question. Often, though, parents need some counseling to get to the point of reporting. And we have to recognize that it's very difficult for a parent to report, especially if the offender is someone very, very close to them in the family. So counseling, non-judgmentalism, persuasion.
Yeah. And I think the issue that I personally have been raising is the fact that when the professionals, which is now back to you, Daphne, when the professionals in the Department of Health, in the Department of Education, even the parents see this child who is pregnant, what is their role? What have they been doing? And you started by explaining to us who in the list of people who have obligations to report is included, Daphne, before your network became a problem. I hope you are now able to continue and define for us, the protocol around reporting. Joanne was adding to the fact that even parents, who refuse to report can be charged. So we need to all know, hence I was saying earlier in my opening remarks, we are holding all of us accountable. It is not only, the nurses, it is not only the teachers, but even us as parents, even us as service providers who are seeing these children have an obligation, and we need to know what we need to do. Let me move because it seems network is a problem for Daphne. I want to bring you in here, Siziwe. You are with the UNFPA, and I'm sure as a program, the reason you've even partnered with Soul City is because you see across nations how big this issue is, how young women are treated, how the issues of young women, in some countries they are given in marriage at a young age. Culturally it's acceptable. They are not their rights are not considered. So what is the UNFPA's position in terms of the rights of the young girls and the many instruments that we have available, and how those instruments are being used in such cases, or how they should be used in such cases as the case where we have statutory rape in South Africa?
Thank you so much, Program Director. I just want to highlight first that in terms of young people, especially the ages that we have been discussing about in the morning, that UNFPA does have programmatic experiences on some of the practices, including marrying young girls earlier, especially in KZN and Eastern Cape. These practices are really prevalent in those two provinces and in specific districts of the province. And you find that as we were discussing the reporting procedures and who is supposed to report, the nurses usually say some of these young people are in marital unions in some of the districts. We know that South Africa is a big country, it's vast, and the experiences will differ from district to district, but the specific districts where these practices are really prevalent. And I think we all know of the case of Jezile that was convicted in the Western Cape court. He was convicted on one count of sexual assault, and one count of simple assault, one count of human trafficking, and 3 counts of rape for a 14-year-old girl in November 2013. We know that some of these men, they take these young people from the rural districts and they move with them to either Western Cape, Gauteng, and under the pretense that they are making them wives. So in terms of the practices that are really prevalent in South Africa, for that matter, in other contexts as well, we know that traditional and cultural practices, they really reflect the beliefs and values of members of a community. And these span in periods, often spanning in generations. And we know every social grouping in the world, not in South Africa only, they have traditional practices and beliefs. And these are sometimes harmful to specific groups like women and girls. We know, for example, in South Africa, one of these practices is a practice of ukutwala, adopting young girls and making them wives to much older men than their age. And one other practice that is really prevalent is the practice of female genital mutilation, which is also practiced in specific areas of the provinces of KZN and Eastern Cape in particular. And I just want to also highlight that through generous support of Canada, UNFPA, and UNICEF, in partnership with Soul City, are implementing a program that is titled Empowering Women and Girls in South Africa to ensure that their reproductive health and rights are really realized. So this, through this program, we were able to engage Human Sciences Research Council to come up with data. We know that we need data to engage communities so that we can see how much are we talking about. If we are talking about child marriage, how many young people are really engaged in this practice, FGM, and some other practices, including the practice of really testing or checking if young girls are virgins. They call it virginity inspection. In terms of prevalence in other countries, as you were saying, Fina, we know that 2 in 5 children are married in West and Central Africa, which is the world's highest rate, and 1 in 3 children in East and Southern Africa, where we are, they are also married young. 1 in 4 are in formal union in Latin America and the Caribbean. So with that data, I just wanted to highlight that this practice is common in other contexts as well. I think Luella has mentioned to us that anyone below the age of 18 is considered a child, but we continue to see young people in union before the age of 18. We know it happens in Niger, in Bangladesh, in Ethiopia, Burkina Faso, Sierra Leone, and other contexts. So it's quite a common practice. But child marriage is really a human right violation, and it threatens the girls' lives and health, and it limits their future prospects. We know that girls that are into marriage, they often become pregnant while they are still adolescent, and that increases the risk of complications during childbirth and also during pregnancy itself. And they are also more often forced to drop out of school so they can assume household responsibility, and that denies them the right to get an education. And we also know that girls who leave school, they have worse health and economic outcomes than those who stay in school. And eventually their children, they fare much worse than them. We know that there are contributing factors or drivers, and some of this is poverty and gender inequality. We know that girls in child marriages, they tend to be less educated, as I have highlighted, and they are more likely to live in rural and underserved areas. And many impoverished parents believe that marriage will secure their daughter's future. And this is true in our development context, but also in humanitarian context, where many parents, they really fear the inability to protect or care for their daughters. They believe that marriage will protect their daughters from sexual violence, which is often exacerbated in times of crisis, especially in humanitarian contexts. In terms of female genital mutilation, in spite of progress that has been made, millions of women and girls, they are really subjected in this harmful practice. We know that countries with high rates of female genital mutilation, they include Egypt,
So,
Guinea.
Siziwe,
Yes.
I'm sorry to cut you because I want us to be focused. I don't want us to be all over with our discussion. I want for anyone listening to leave here with a clear understanding. Today, we are talking statutory rape, and we want everyone to understand why it's a big concern for us when we see a 10-year-old pregnant. I think we can enter discussions on other practices that are harmful to children and create a platform to discuss those specifically. But I want us to limit our discussion today to understanding age of consent, to understanding what the responsibility is when the statutory rape that has happened. Who do we hold accountable? How do we hold them accountable? How do we get to see cases being reported, and ultimately how do we see prosecution? So I'm sorry to cut you as you were explaining, but I want us to focus and bring it, and zone it in, because there's a lot of confusion in terms of understanding the different ages. I think the law, in how it defines the different age of consent for this and that, brings in gaps, and that is why maybe Joan was saying she's yet to see successful prosecution on some of the matters because of the fluidity, sorry, of some of these things, as Managa Pillay was saying. So let's bring it back. I want to bring in Childline, because Childline is also doing work around supporting children who have been violated. And I know mental health is one of the big areas where we fail as a country to provide the right support, the right environment. We don't have half enough resources to do that. So, Childline, please do come in and tell us what is the support that you offer when a 12-year-old has been violated and they are presented to you for support. How do you help them? Do you help them open cases, or does it only end with providing psychosocial support? What are the steps and processes that are involved in helping these children?
Okay. The processes that Childline does. Childline, okay, first of all, Childline is a child protection organization that advocates against violation of children's rights. So mainly we focus on abused children in all forms, different types of abuses. So our role is when we receive cases, we assist the child in understanding what is abuse and the steps in which we are going to assist in trying to help the child report. Because we are a helpline organization, we mainly operate on the cell phone. So we would receive calls, take all the necessary details, the name of the child, where the child resides. We do accept people that actually report children as abused, but they want to remain anonymous because of the privacy and confidentiality clause, and because they reside in don't be labeled as whistleblowers or as people that are trying to disrupt or have jealous towards the other household. So when we receive those cases, we refer them to the nearest
social development or any child protection organization. Then we follow up on what is the progress. We provide psychosocial support to these children, we provide counseling. If the child resides near our offices, to provide therapeutic services. And we do not work with children in isolation because a child comes from a family and a community. So if we feel that and see that there's a necessary need for more intervention, that and maybe our offices can try and assist in terms of the where are we demarcated in or the demarcation area. If we are nearby, we would actually go to that community, meet with the gatekeepers, try to understand what are other challenges that they are actually faced with in the community. Um, Create a program synopsis for a certain program that is going to link up with the certain issues that the community is. Implement that certain service in that community. If, let's say, there's a lot of instances of statutory rape, then we are going to create a program of statutory rape that is guided out by our policies and procedures of the organization, and we would implement that in that community, do all the intervention processes and programs, and evaluate the effectiveness of the program at the end of the program. And thereafter, when a child is being reported, let's say the child is being raped or the child is being detected, we refer those cases to the nearest designated child protection organization, because we do not provide statutory services whereby we would actually go with the child to court and attend the court process with the child. But I believe that other provinces, because we are based in Eastern Cape, other provinces do provide court preparation processes whereby the child will be, let's say there's a trial in case the child is going to appear in court. The child is going to be prepared on what it is that the child needs to be aware of when they actually appear in court, and all the processes to ensure that the child is not to prevent secondary victimization, because court can be really intimidating, and the child can panic and they would want to actually close the case, or just because they fear of what will be the end result. And courts can be really intimidating, and lawyers can be intimidating for the whole process, to ensure that the child will be provided with the necessary support in court. So Childline does offer those services. So that is what we provide as Childline. It's basically psychosocial support, therapeutic services, counseling, referring those cases, court preparation. So that is what we do as an organization. Thank you.
Okay, so you're basically saying if there is a child and there's a parent who needs assistance because they really want justice for their children, they could come to Childline and you will help them understand the process. You will hold their hand as they go through the process, but you will also provide the counseling that is needed so that in the process the child, is restored, mentally, emotionally. They are helped to recover from the trauma that they have faced. Am I
Yes,
capturing the services correctly? Thank you. I
yes,
still
yes, that's
wanted
correct.
Daphne to answer. Thank you. I still wanted Daphne to answer to the issue of, the responsibility that public servants hold. She listed a whole lot of individuals who have a mandate to report. And I like the question that Mpomo Happy is asking. Mpo is asking, when a 10-year-old gives birth in a public or private facility, how does a healthcare provider report so that the perpetrator is known and they are then called into account? How do we ensure that the court decides if there was statutory rape or not, since it cannot just be referred to as teenage pregnancy? I wanted to understand, Daphne, and I hope this time your line is clear. I wanted you to help us understand what I call protocol. We engage a lot with healthcare facilities that tell us there's a form that needs to be filled. And seemingly no one knows. Some don't know about that form. If they do, it's like you can choose to or not to fill it in. Even if it's filled in, there's no follow-up as to what happened with the form. So the obligation to report is something that is not really taken seriously. And I saw Magna was saying maybe they don't have capacity, maybe they don't know the responsibility that comes with the positions that they hold. What is the process, and how do we then build that capacity to avoid us being in a situation where we keep asking ourselves, what happened? Why is this case not being taken forward? Why don't we see anyone being arrested? But yet we see so many numbers. Numbers have been coming out every year in terms of children giving birth. Daphne? Brenda, are you able to speak to that? The question that I asked Daphne.
Okay.
Thank you.
Good morning, everyone. I don't know whether should I shoot to the question or must I give a little bit of the background of our program or our directorate?
You can do that. In summary, then answer the question.
Okay. I'm Brenda Skosana from Department of Health under the directorate called Clinical Forensic Medical Services. Clinical Forensic Medical Services render services to victims of crime and perpetrators as stated in the National Health Act. So there are different sub-programs in Clinical Forensic Medical Services. There's a prevention of injuries and unnatural death. We've got the PEP, that is the response to care. The prevention is at the provincial level. Then we've got PEP, management of a patient once the event has occurred. Then we've got a VEP, whereby we restore the dignity and we capacitate the survivor to deal with what has happened. Then I will just zoom into the topic of today, that is about teenage pregnancy, child abuse, that includes sexual abuse of the little one. Yes, the 10-year-old cannot give a consent. Less than 12, they cannot give a consent. However, we are having those cases, and unfortunately, at this stage, some of them, they are not being reported. But in our facility, let's say we get a child that is 10 years, because of we are dealing with victim of crime, definitely that case will be reported to the Child Protection Unit, and it will go to court for prosecution. But where we are having challenges, it's when the child give birth at the hospital, at the maternity unit. Then there is a problem in terms of linkage and active referral, in terms of healthcare worker reporting those cases, because you can't be sitting with the 10-year-old. The 10-year, I do understand from 12 years, 13, 14, as it's been explained that who can give a consent, and we must also take into consideration that a 13-year-old can impregnate a 14-year-old. It doesn't matter in terms of the boy. What matters is it's a puberty. Like as long as the person can, the sperms have been produced, they can ejaculate, therefore they can impregnate. But in terms of the 10-year-old, that one, all of them, they have to be reported. They have to be referred to our facilities, because fortunate enough in Gauteng, we've got 26 facilities, 26 designated facilities, the clinical forensic, that includes 7 TCCs. And those facilities, they are based in the hospitals or CHC. For those hospitals or CHC that are fortunate enough to have those facilities, they are at a better advantage of referring. So I don't see any reason why people, they wouldn't refer those cases to clinical forensic medical services, so that we can take it from there, because there's evidence that need to be collected. We must involve the police. We have to go to the court and give the testimony as the expect witness. So currently what is happening, we find out that, I think one of the speakers also alluded to that, to say that some healthcare workers, they are not aware about the laws. Yes, we do have the laws, and honestly, it's not easy for one to sit and read the laws. If you can just check the Sexual Offences Act, it's not an easy act that you can interpret it on your own. You need a custodian of that act to come and explain, so that they can unpack and there will be questions. So what we are failing is to implement those acts. One of the reasons might be that people are not capacitated by the expert or by the custodian of the act, and share their experiences in terms of feasibility to implement the act, because there are technical errors and technical problems that might emanate from trying to implement the act. I'll make an example of the CTOP. Yes, we have tried as healthcare worker to engage with our colleagues to say, once they have come across a child that wants to terminate, they have to refer to us. But they are saying that the act allowed them to terminate, and they are scared that some of them, if they do alarm them, that they need to refer them to us and explain to them what are the reasons that they are referring, they might go and do the illegal termination, that it's a backstreet termination. Some of them, they threaten to kill themselves, hence they will end up not wanting to refer them. But that is not an excuse. I think we're going to talk about the measures or the strategies that have to be put in place to ensure that the laws are being implemented. So the problem is that the 10-year-old would not come to us. When they go straight and give birth at the maternity unit, then we miss those cases, because some healthcare workers, they do not refer to them the way they're supposed to refer. So I think it's the issue of accountability and responsibility. So because I think it's not fair, because it becomes like a cycle. We are not really assisting our little ones when we are just going to leave it at that. So I think the next step is to investigate where the cases, where are those 10-year-old gave birth, and what were the measures that were put in place to address or to refer them to our facilities or to report them to the police officers. But like a healthcare worker, irrespective of the guardian, if the guardian, they don't want to report, as a healthcare worker, you are mandatory to report on behalf of the child, because everything that we do, it's in the best interest of the child. So if the facility has got a clinical forensic medical services, you can refer that child to clinical forensic medical services. Then we will hand over the case to the child protection unit. We know what is it that is needed, and we know how to talk with the little ones. But another thing is that some of them, the issue of disclosure, we have also to look into that, because it's a process to disclose. So the issue of disclosure is another element that we have to explore as healthcare workers. I don't know if I've got your answer, your question, sorry.
You've actually confirmed to me that there's a lot that needs to be done, and it borders on how in our country we have many laws, but we don't know how to apply them. We have many laws that are good in intention. Their intentions are well and good, but we fail at implementing those laws. We fail at doing our duty as duty bearers. And that is why we see the gaps that we see. The form that I was referring to, somebody has actually corrected me there. It's Form 22.
22.
I remember that when we raised this
22,
issue
yes.
in one of the meetings with healthcare workers in Limpopo, and we were saying, but what do you do when a 10-year-old is pregnant? Don't you have to report? It was for the first time that nurses were hearing about Form 22. And then that says to you in their training, what is it that they are told when they are being trained? What is their responsibility? Who must then hold them to account. Remember, we are talking about holding each other accountable. Who has the responsibility to make sure that the numbers that the public gets to see in the newspaper, are supported through a Form 22 and a J88? And I don't even know the difference between the two, but I know that there's a Form 22 and there's a J88. But I don't know who must fill in Form 22 and who must fill in J88. And I don't know what happens when Form 22 and J88 are not there. I don't know. And that's what I want to know. I want to know how, as a parent, I need to go to a clinic and say, when I bring my 10-year-old and say to a nurse, can you and I fill in Form 22? Because then at least I'll be showing that there must be something that needs to happen. And when that form is filled, how does it end up at DSD? Because at least the little I know is that it must go to DSD. And that is why I'm struggling, and I keep asking Daphne to come, but somehow Daphne's...
I'm back in, Chair. Chair, I'm back in, and I'm open to answer those very questions as well. Okay, I've just used a different device, and hopefully I stay in. Absolutely, and I think it's important. I think the colleague just spoke about the filling of the Form 22, but it's not about just the filling of the Form 22, because what is the Form 22 supposed to do? Now, we said that the mandatory people has to fill out the Form 22 and then submit it to the Department of Social Development or to a child protection organization. Your child protection organization are your designated social workers so not all your child protection organizations are designated. So in other words, like Teddy Bear Clinic, they are not designated child protection organizations, which means that they cannot do then, the removal and placement of children. They can't investigate the care and protection of children and so forth. So you need to look at which are your designated child protection organizations, and then obviously Department of Social Development, they are designated to do something thereof. Once we receive the Form 22s, it means a designated social worker needs to investigate the case to ascertain whether the child is in need of care and protection. Don't take it for granted, because any child below 18, if that child falls pregnant, it means that there is something that is untoward that has happened in that family, because there could be uncontrollable behavior, could be many other reasons. So therefore, a social worker will then be allocated to the case to investigate immediately. If that social worker finds that indeed there was abuse or deliberate neglect of that child, that social worker within 21 days after the conclusion of that investigation will then fill out a Form 23, so that to confirm indeed from a social worker's perspective that we have found there was abuse and neglect of that child. Form 22s and Form 23s finds its way under Part A of the Child Protection Register. Because there's two parts. When we talk about a child protection register, it's kept with the Department of Social Development nationally, whereby they will have, there's Part A and Part B. The sexual offences register is kept with the Department of Justice. But however, you will find that information from the sexual offences register, if that person is found guilty, it will find its way under Part B of the Child Protection Register. Now, what is very important is, remember, you are talking about nurses, but beyond nurses, you're having your medical doctors. They are the one that actually, perform these procedures and so forth. So if they are the first to know that the child is indeed abused, if there's child coming in being pregnant, then they need to follow the Form 22 like any other professionals in the health facility. Now, let's talk about non-compliance to reporting. Section 305 of the Children's Act, it talks about offences, and it says a person is guilty of an offence if that person, in terms of Section 305(1)(c), fails to comply with Section 1101. And Section 1101 talks about reporting of abused and neglected children. Section 305(6) states a person convicted of an offence in terms of Section 1, which is your reporting, is liable to imprisonment for a period not exceeding 10 years, or both to a fine and such imprisonment. And Section 305(7) states a person convicted of an offence in terms of Section 1, which is reporting, more than once, if so that person did not comply more than once, then that person is liable to imprisonment for a period not exceeding 20 years, or both to a fine and such imprisonment. So please understand, beside the reporting, every other services in terms of the Children's Act that way you are mandated to provide services, the Children's Act creates statutory offenses, which is then becomes a criminal offense. So you're not held accountable in terms of just the children's court, you're held accountable in terms of the criminal court for not adhering to the services that is required to a child as delegated by the Children's Act. Can I also say this further? You know, we're talking about rape and statutory rape and so forth. We must not get stuck with just the technicalities around this. All cases of a child where the child is pregnant must be reported. Put it in that term, and let the social workers, designated social workers, to then unpack and then unclear, you know, and through the courts, what will then happen to the children. Because when you talk about rape, it's not just rape. We have rape, compelled rape, sexual assault, compelled sexual assault, compelled self-sexual assault. And I think you know, when he was speaking, he said he could take an entire day unpacking the Sexual Offences Act. So, and clearly so, because we're just touching on some aspects, colleagues, but we're not going through a lot. And I think it's quite important I make this point. Colleagues, when we talk about especially incest, and I think I want to get to that point, because we ask who are the perpetrators of such children, and they're not far away. They are family members. In most cases, they are family members, and one needs to then understand what is incest, because that is in relation to incest. And Section 12 of the Sexual Offences Act clearly states, and it prohibits sexual acts between family members regardless of the age. You know, it doesn't matter of the age, it's prohibited, right? And then, so we need, and when we look at, you know, who are family members, we talk about, you know, in terms of blood relations, we talk about in terms of affinity, and we talk about in terms of adoptive relationships, you know, adopted children with their parents. Because we are finding more and more adopted children as well, you know, being abused by their adopted parent because they don't see this as a blood relation, but not realizing Section 12 prohibits such. And I think it's important that we look at that. Also, colleagues, what we need to look at is pornography. Because, and I'm talking from a practical point of view, when I used to be a probation officer many moons ago, right? Many children that enter the criminal system for sexual offenses, we have found, when you look at the you know, the cause, because there's always symptoms, but look at the cause as well. Yes, family dynamics, family relationship, you know, social ills in families play a huge part, which needs to be addressed. But beyond that, you find children have access to social media. And at that stage, and I'm talking many moons ago, it used to be TV. And now you can imagine 20 years or 30 years down the line, we're talking about technology like Twitter, your Facebook and so forth. So children then have access to, you know, TV, where they are allowed to watch. We don't censor these programs. And what we found is pornography, and we all know that pornography is accepted in this country. It's not a crime to, you know, to have access to pornography, but showing pornography to children is a crime, and child pornography is a crime in this country. And I think, and the other two issues that we need to come on par when it comes to sexual offenses is cyberbullying together with sexting. I think those are other two critical issues, colleagues, we need to look at, because we need to unpack that, because that all, you know, is part and parcel of your sexual offenses in its entire, when we look at it integratedly, and so forth. But just to add to as to why we're having more and more people not reporting, one is ignorance, very much so ignorance of the law, where civil society surely don't know, one, their rights. And even if they do go to people, you know, for assistance, we're finding the very people that ought to know don't know. Now, can I just make this point? And I think it's extremely important, especially for professionals that are sitting on this platform or hearing this aspect. I want to go to, you know, the fact that when we talk about having ignorance of the law, and it's good that we have a law person here, because the term is usually ignoranta juris non executat sat, which is ignorance of the law excuses. So in other words, you are free to make whatever choices you want, but you are not free from the consequences of those choices. In other words, presumed knowledge of the law is the principle of jurisprudence, that one is bound by the law even if one does not know of it. It has been identified as a prohibition of the ignorance of the law. So therefore, all professionals that are sitting here, you cannot justify your conduct on the grounds that you are not aware of the law. So you can't say, I did not help the client, I couldn't help the client, or I just did not, for whatever reason, because I did not know this. Unfortunately, that's not going to work if you're going to be held accountable. If you are in this, if you are in this platform to protect children, then you will protect children whether you like it or not. So it's just a park and comply issue. So how do we get to know? I think in platforms like this is very important. But if you are a social worker, if you are any social services professions, if you are mandatory people to report, and I'm like I said, I've done a lot of training with the Department of Health as well, and it's shocking to know that the health professionals don't know what they ought to know in terms of reporting. Colleagues, just one more aspect I would just like to add. There's very much conflicting issues when it comes to sexuality. Look at the Marriage Act. Marriage Act, in terms of your civil and customary law, allows children to get married from the age of 12 for girls and from the age of 14 for boys. And obviously there's processes that they need to follow, where you need to get the consent of the girl and boy, you need to get the consent of the parents, and in civil law you have to get the minister of Home Affairs to give permission, and in terms of customary you've got to get permission from the minister or any other delegated person. So if we're allowing, and why we say 12 and 14 is because of the age of puberty. So imagine we are allowing our legislation allows children to get married, right? Then obviously they become emancipated. Then they can have children. Then they can they can make therefore we must not confuse a lot of aspects when we come from a cultural point of view, because some of our laws really contradict and is conflicting. Because imagine children from the age of 16 is allowed to have sexual relationships, right, consensually. So simple example, if a child is 16 and a 60-year-old wants to sleep with that child, and the child agrees and the 60-year-old agrees, and there's nothing untoward, nothing by law can hold them accountable. However, social workers is not so clear cut, professionals is not so clear cut, because what if there was sexual grooming in that relationship, and that's a crime. And so we need to really look at these laws in depth. We need to really understand them. We really need to unpack them and not just turn away, civil society when they come to us for help. And most of the time they are turned away is because of the ignorance of professionals. But can I say this? One of the ways to really get people to understand is to start empowering even civil society. Because if civil society understands their rights, I promise you they will start holding professionals accountable. Thank you, colleagues.
Yeah.
I'm hoping I've covered some of the aspects.
You did, and I wanted to follow up before I reflect on what you've said. So how many cases have you seen come through the Department of Social Development? How many, where we are sitting right now? Do you know of any cases that have been prosecuted?
At this stage,
Sorry, I was just disturbed here.
Oh no, it's fine. At this stage, I'm sorry.
The question. Let me ask my question clearly, so that so I'm asking, given that we know that there's these forms that you mentioned and the process, Form 22, Form 23, and then J88, do you know of any that have been successfully prosecuted through the reporting that has happened? As much as reporting is still a problem, but do we have some successes where we can say we know of cases that have been reported and that have been prosecuted?
At this stage, no, but let me give you a reflection of where we can see the inroads around this. If you look at Part B of the Child Protection Register, right? And remember, we talked about children children that are abused and neglected, right? So we talk about Part A, and I told you what goes under Part A. It's your Form 2s and your Form 23s, which a social worker does. But under Part B is when a case is received via your courts. And the courts make two determinations. One, the person is not allowed to work with children. and 2, the person is found guilty for whatever offense. So that information goes under Part B of the Child Protection Register. So therefore, if you look at the names and the number of names under Part B of the Child Protection Register, that gives us a good indication or a reflection of those that are, you know, and remember, a lot of your sexual offenses cases will find its way under Part B. That will somehow give us a reflection. But I think going forward, I think after the lid has been opened up on the cases that comes with children, especially where the Department of Health has come in, and now you looked at the Department of Education reporting on these cases, and together with the Department of Social Development, I think going forward, these are the things that one needs to look closely. And I just need to say this with the Department of Education as well. I think many a times we do understand with the Education Act, children up to the age of up to the end of age of 15. Or the end of age of beginning of age of 16, it's compulsory for a child to attend school. Now you find many of these children are dropping out of school, and we need to report this, because that makes it a child in need of care and protection. So you know, you have these different, you know, gaps where we can filter, you know, a way of ensuring that these children enter the system, you know, a child protection system, where they get the necessary, you know, care and protection, and their rights are not violated thereafter. But lots of times we're having professionals not reporting, not working together, not being integrated, and I think it's important that we start having these conversations and start empowering each another in terms of that. But that will be a good indication to tell us what are the cases, and I'm sure Department of Justice as well is able to give us those numbers, especially lots of these courts also have specialized sexual offences courts as well to work with these types of children. But can I just say this? What is also very important, one needs to understand, why do we take a Form 23 from a social worker? A Form 23 is when a social worker confirms. Remember, when a case goes to court, that's facts. When a case deals with the social, that's probability. And sometimes not all facts is put on the table for a conviction. And you can't always go to that. But a child needs that care, protection, and going forward, the rights being seen. And most importantly, don't forget, beside the child that has been so-called in the, you know, raped or in sexual part of the sexual offenses, there's also a baby to that child that needs to be taken care of. And we don't want to repeat the cycle of that type of abuse. So we need to work with that entire family and community, because what is important when we work with interventions, we don't only need to work with that individual and that family. That victim and that perpetrator comes from the very same communities. So what are we doing around the programs? What are we doing around our awareness programs and our interventions in those communities? Because both are coming from the same environment. So from a community level and from an awareness level, what are we then doing and what are we saying? Thanks, colleagues.
Yeah, and I think this is where we need to call for legal reform. We can't have the law permitting a child to be married, yet we call it a, you know, violation of a child, a human right violation when a 12-year-old is pregnant. You know, so if the law is confusing us in this way, then we need legal reform. We need to call for the law to change. It can't be either or. It must be very clear that a child is a child, and therefore a child must be protected in totality by the law. There can't be provisions in the law that says a child can be violated only if they are legally married, because that's simply what the law says when they say you can be legally married as a 12-year-old, you know, but it says when you are 12 years and under and someone is having sexual intercourse with you, it's rape. So it's like they are saying you can be legally raped. And that's for me uncalled for and unacceptable. And I don't think it's something that we need, you know, to just dismiss as it's what the law says. We need to take action against such provisions in the law. And I think this is what you were saying, Siziwe, when you were talking earlier about the human rights violation that comes with child marriage. And we see such practices, you know, I think we only noted the ones that were happening under culture, like ukutwala. But you are telling us today, Daphne, that the law permits, and Nelly was asking which law, because I think we need to interrogate that law, and we need to really hold people to account on such provisions. I think I'm disturbed by the fact that our country can have a law that permits people to legally rape children, and they get away with it because then they've married you. You know, how you are a child, how do you have a responsibility of being a wife? And Joyce, I want to bring you in here. You work a lot with children. You do
So
a
sorry,
lot of
maybe
work with
sorry, Chair. So sorry, Chair. Maybe
Go
maybe I
ahead.
must just answer your
Go ahead.
question. Your question
Yes.
was which law permits, you know, marriages. And when you
Yes.
look at your marriage in terms of civil law, you must look at Marriage Act 25 of 1961, Section 26(1), read with Section 17, and 18(3)(ci) of the Children's Act 38 of 2005. Also Section 12(2) of the Children's Act, read with the common law. In terms of your customary law, marriage, you need to look at section, also the Recognition of Customary Marriages, Act of 120 of 1998, Section 3. You also need to look at Section 12(2) of the Children's Act, read with the common law. So these are your specific sections that talks to that. And can I just add, in terms of violation, and I hear you saying the violation of a child's rights, but can I also add, as professionals, we're also violating the child's right to have access to condoms and contraceptives without their parents' consent, which is from the age of 12. So every child has a right to have condoms and contraceptives, right, from the age of 12 without the parents' consent. And like I said, the offenses, if you do not give that child that condom and contraceptives, accordingly, you will also be part of that offense that I mentioned earlier on.
Yeah, there's so much that we need to unpack. So please put that in the private comments so that it can be projected for people to see all the different acts that you were mentioning, because I don't think we were fast enough to write them as you were saying them. So if you could be so kind, Daphne, as to write them, and then they can be projected. And it's worrying. All the issues that we are raising here worry me, because we continue, and I know that we want to be progressive, and we want, you know, as a country, given our history, to really accommodate everyone with our laws, with our policies. But there's a fine line between what we should accommodate and what we should do to safeguard children. And I think this is what we are raising here, that all of us has a duty and a responsibility to safeguard children and to make sure that we know how we contribute to violation when we don't do what is required of us. Like you mentioned, if we don't provide the condoms, if we don't provide the contraceptives, if we don't provide what we are supposed to provide, we need to know that we are part of the problem and not really helping solve the issue. I wanted to bring Joyce in because we are running out of time. Joyce, you work a lot with children in the Soul Buddies, and we've been talking about educating children, getting children to know, you know, their rights, not only their rights, their responsibilities, because you can never talk about rights without talking about the responsibility that comes with those rights, right? And the 12-year-olds, the 13-year-olds are children that you see a lot in the Soul Buddies clubs. What have been your experience in terms of the children and their understanding of, you know, consent? Do they talk openly about issues that they face? Do they have an understanding of what they are being taught in the, you know, life skills classes? You know, are we confusing children? Do you get a sense that everything that we say confuses children, or what is your sense in as far as interacting with children, Joyce, in the work that you do?
Thank you so much, Sis Fina. All protocols observed. I think as a voice of children and young women, we are really, really concerned, especially when it comes to the age of consent, when it comes to sexual activity. I think our children are very confused in terms of the terminology that we are using when we are trying to sensitize them around the issues of sexual behavior. And now, listening to all the presenters in everything that they've been saying since this morning, I'm really worried. I feel like it's time for us to move from awareness to accountability, because we hear so much stories of healthcare workers have been trained. They know what to do when a child comes and report she's pregnant and everything. But then now the question is, in terms of activation, there's a difference between training a person and activating what has been trained. So I think there's a gap between, we are just giving them trainings, but then no one is monitoring the activation part. Uh, no one is wrong in terms of the way the presenters were presenting, in terms of saying, no, our healthcare or care workers knows if a 10-year-old comes and is pregnant, they must complete form 22, whatever. The question is this thing being activated in the local clinics? Have we ever saw them in some of the clinics happening? So I think our children are really confused in terms of consent, especially with parents, because especially considering the backgrounds of the areas in which we are working in. These are the deep rural areas where we talk about poverty, where parents can do whatever it takes in order for them to get a source of income. So some of the cases, they end up not being reported, because you'll find that a 12-year-old or a 9-year-old, let's say, let's go back to the stats that has been shared recently, where 688 children between the ages of 9 to 10 gave birth only from last year, April, till this year, March. This, it says to us, there is still a lot of work to be done. How can a 9-year or a 10-year-old be led to go through the full term of pregnancy and give birth? What went wrong? The first day when the child comes to the clinic for consultation, what was your role as a healthcare worker? Did you involve SAPS or DSD? Was the case open? I saw there was a question from one of our participants there regarding the issue of, for the teenage pregnancy cases that were reported, are there cases that were referred to CPU? I think that the challenge is we are working in silos. We come, we sensitize our soul bodies, our rise members at schools, we share information, we do everything. But then on the other hand, the other departments will also come do their own thing. I think it's time for us now to join hands together and speak the same language, instead of trying to confuse our children even more, because this even add in terms of them being more afraid to come out, and report such cases, because they don't know. If you can ask a soul body to say, where do you start if you are raped by somebody in the family? Where do you start when you want to go and report? They will tell you, I've been raped by my brother, by my mother's boyfriend. And if I told mommy, she's saying if I tell somebody, we won't have any source of income in the house. What must happen there? So if we were not working in silos, I think it was going to be very much easy in the work that we are doing. So it speaks volumes in terms of, yes, there are laws. Yes, there's information that is being shared. There are trainings that are running every day. But in terms of activation, accountability, where are the perpetrators? We see the teenage pregnancy stats, but then we don't see the stats in terms of, from the 688 children who gave birth, so many perpetrators. Cases are still in process regarding those teenage pregnancy cases that have been reported. So there's a huge gap in terms of reporting.
Yeah. And I think definitely confirmed for us that as far as she knows, she can't tell us of any numbers. And that's really the sad reality that we are faced with. I want us to start rounding up our discussion. There's so much that has been said, but for me, the key take home that I at least have clarity on today is that any 12-year-old, a 12, 11, 10-year-old, any of those that have engaged in sexual intercourse, even if they've given consent, that is considered rape in law. So when someone has engaged with a 12-year-old sexually, that person must be charged with rape. Any person who engages with anyone below the age of 16, 15, 14, going down up to the age of 14, that person should be charged with statutory rape. So that's how we draw the difference between rape and statutory rape. And the other thing that I got very clear today is that everyone has a duty to report any violation of children. You are a doctor, you are a nurse, you are a priest, you are a teacher, you know, you are a social mobilizer working for Soul City, you are Joyce who's working for Soul City doing community mobilization. If you know and if you come across a child who's being violated, you have a duty to report. And we know today, at least, that if you fail to report, under Section 305, non-compliance to reporting, you could be sentenced up to 10 years for not doing your duty to report. Anyone who refuses to report for whatever reason, you can be charged. And I like the fact that you are bound by the law, even if you claim ignorance, even if you say, but I didn't know. You not knowing is not a reason for you not to be persecuted. So we need to start educating ourselves. We need to start understanding, especially when we are in positions, similar to the positions that we have, to understand what is my role. Your role is not just to be there and a salary. It comes with huge responsibilities, and we need to be very clear. We have not really engaged on the issue of incest, and that's something that we need maybe a session on, because incest is happening a lot within what we are calling statutory rape and many cases that we are referring to. There's a number of cases that could be incest or are incest cases, but we don't even deal with them as that. And naming is important. We need to start naming things correctly, because it's in understanding and naming correctly that we start dealing with issues the way they should be dealt. Hence, we've been saying we cannot continue talking teenage pregnancy. We need to start talking rape. We need to start talking statutory rape. We need to now start talking incest, right? So that's what I've learned today from this session. I also learned that we do have laws, but we don't have knowledge on how to apply those laws. Or we don't have personal interest. We are not invested in doing that part of the work. We are invested in earning a salary. Some people tell you, I entered this profession because I knew I will start get paid. I will start being paid while I do, while I study, while I do my practicals and that. And we must admit, not everyone is there because it's their calling, as I call it, right? So they are just there, and that is why some of these things don't touch them personally. But we have a duty, and I cannot underscore that enough. We have a duty, all of us, to safeguard children in this country. No excuses. You cannot claim ignorance. That much I take home. You can't claim I didn't know. So we need to really start doing our part. And so I'm going to ask our panelists briefly, and to everyone who's been sending suggestions, questions, our panelists have been trying to respond. And if you see in the comments, Soul City has been sharing the responses because we could not give each and every one of them, to speak. So the questions are answered. I believe all of them have been answered in the comments section. When you get a chance, just go through them again and get a clarity. But we will also post them. I think I will ask my team to do posters, that we put on social media the way we normally do, where we clarify some of the things that have been spoken of here. But before I close and then give to my panelists to say their parting shot, I am disappointed in our law and in how our laws actually create an enabling environment for violation of children, in the contradictions that are there. And I am calling on fellow activists that we do something. We don't just, accept the status quo. We need to challenge it, and let's find ways to challenge what is happening. we can't have legal rape being allowed. Tobile seems not to be answered. So if we are able to answer the question that Tobile asked, please, can someone look at that question, because she's asking what is the answer to the question that she raised. So 1 minute each. I'm going to ask that you give closing remarks, and please keep it to a minute. We have run out of time. Let me start with you, Llewellyn. What are your closing remarks?
Thank you, Madam Chair. From my side, I think it's time we take responsibility for our actions. That is paramount. And not only taking responsibility, but also accepting that if we do not take hands and join the effort, we will not proceed and progress. So from my side, I think it's important that all the various stakeholders participate in this debate, and that we share the information and the knowledge, because like you indicated correctly, saying that I didn't know is not an excuse at all. I'm looking forward to continuing this debate with all stakeholders in future, and let's take hands and take it further from here on. Thank you.
Thank you. Siziwe, closing remarks?
Yes, thank you. It's clear to me that we need to enable those professionals that were mentioned, health, social services, and other professionals, so that they are able to report these cases. But we also need to strengthen education and economic support for families of these girls, because sometimes, I think we heard, sometimes parents benefit from these practices. We also need to foster community discussions through SBCC initiatives, and also support collective commitment at a community level to ensure that these are reported. Thank you, and back to you.
Thank you. Joyce, closing remarks?
Okay, I think we really need to go out there and mobilize our communities, especially the young women and girls, and especially on the integrated services of SRHR and GBV. We no longer have to approach these two as different programs. We also need a multi-sectoral approach when dealing with such cases. I think that's it from my side. We must stop working in silos.
Thank you, Brenda. Whoever is not speaking, please mute yourself.
Okay, mine will be creating a safe space for disclosure, and also therapeutic support, so that we can have therapeutic support for those ones who have disclosed. Also to check off socio-economical structures. And I think engaging boys, I think now we have to move, and we must also focus not only on the girl child, but we have to also engage boys, because they feel left out, and they have to understand as well in terms of sexuality and what are the responsibilities. Yes, people have to know their rights, but their rights comes with the responsibility. And I think one critical stakeholder that is missing here is SAPS. I think they are playing a very critical role, because some people, they will complain that they have reported, but nothing has been done. So I think we have to identify all the role players or critical stakeholders. And I think, I hope that this is not the last time we are having such a discussion, because it's fruitful. And the last one will be the strengthening of referral system. Yes, we are working in silos. I think it's high time that we have to strengthen the referral system, not just refer, but active referral system, and also feedbacks, so that we can understand, once you have referred, do the follow-up and find out what is it that was done. Creating a database again of those ones who have been trained, so that we can hold them accountable of their actions, and there should be no excuse of I didn't know. Thank you.
Thank you. Daphne?
Okay, thank you. I think for me, from the Department of Social Development, as the lead and oversight of children, the protection of children and gender-based violence, I think the department is really committed. And I think what we then need to have is that it's not about just doing the right thing, but the challenge is what is the right thing to do. And I think it's important that we all work together you shall provide the services that is expected out there to the communities and to the beneficiaries. If we only take the laws and operationalize it, we do have great laws around the protection and the care of children, and to ensure that their rights are upheld. If we all just we just work integratedly and ensure that, if one person dropped the ball, unfortunately, it has a rippling effect. So all of us need to hold each other accountable. We also need to assist each other where possible. And, as much as it's very easy to point the fingers, that's not going to help the child or the community at the end of the day. So what is it that we need to do differently? More importantly, what we need to do now that we need to do differently, because it's not about what's going to happen, it's what already has happened. So I think it's important. Social problems are growing. Likewise, you see, it's going to have a rippling effect. It's not just about the child, it's more important about the child that's also been born from that child. So we don't want to continue with the cycle of that type of abuse. We need to change that narrative going forward. Thank you.
Yeah. And I realized that today's conversation, we did not get to the solutions, because we need to understand the bottlenecks. We unpacked the bottlenecks, and today we got to a layer that in any of the platforms I've engaged in, we've never touched on. We've never really touched on the many gaps that are there in the legal system. We've never really touched on what the responsibilities are of the professionals, and we just know that there's this chain. There's education, there's health, there's SAPS, there's justice, there's DSD, but we've never really looked at who and how do all these different ministries, how do they come together in making sure that we attend to the issues. So I'm going to ask that the powers that be allow us to have a session that follows up on this session, where we now look at practically what can we start doing, because we are program implementers. In programming, how do we then make sure that we address the issues that have been highlighted here? How do we start, from the bottom, and how do we involve communities? Because we realize that they play a major role. While they are there, they need to be informed, they need to have information, because they are part of the response. So let me give you your closing remarks. UNFPA Canada, our colleagues in Canada, you are now in South Africa, right?
Yes, thank you. I am officially in Pretoria and benefiting from, even though it's raining, it's snowing in Canada, so I'll still take the weather that we have here comparatively.
Yes.
But yes, I'm not going to repeat everything that everybody has summarized. I think all I can say on behalf of Canada and the work that's being done through our support through this project, I think it's so important and so essential to be able to deliver on some of these issues that are happening every day, that are impacting people in their everyday lives, youthful youth especially. It's extremely important that we take action, that we don't sit still, and that, as you said, many of you, we have to work together and stop working in silos to address them. I think that's the most important thing that I came out of this. And so I think I've seen many comments in the chat that says, thank you so much for enriching and informative sessions. I'll join my voice to that to say it was so good for me to hear what's happening in country and on the ground. So thank you all to sharing your experiences and your expertise. And I look forward to the future session that you'll be holding to bring it to the ground and see how we operationalize it and take it forward. So thank you.
Yeah. Thank you, everybody. This was indeed eye-opening. And again, we don't just want to have conversations that are not followed up with action. So I am calling on everyone to come and put your head together in terms of operationalizing the issues and the solutions and really solving the problem. We want to solve the problem. We don't want the next generation to find the same issues. Thank you, everyone. Have a fruitful day, and let's continue doing our work, knowing that we are to be held accountable and we might spend 10 years in jail for failing to do that. Bye, everyone. Thank you.
Thank you. Bye-bye.